Imagine your employer transfers you to a different job. Your pay stays the same, your title stays the same. But your schedule gets worse, your responsibilities change, and the new position is less desirable. Can that still count as illegal workplace discrimination? That was the issue in Muldrow versus City of St. Louis, decided by the U.S. Supreme Court in 2024. Sergeant Jatonia Claiborne Muldrow worked for the St. Louis Police Department. She had a specialized position in the department's intelligence division, where she worked on investigations involving serious crimes. Then the department transferred her out of that unit. Muldrow claimed the transfer happened because she was a woman. Her replacement in the intelligence division was a male officer. Now, Muldrow did not lose her rank or her base salary, but her new assignment was different. Her schedule became less predictable. Instead of having a regular Monday through Friday schedule, she had to work rotating shifts, including weekends. She also lost access to an unmarked take-home police vehicle that came with her previous assignment, and she said her new duties were less prestigious and more administrative. Muldrow sued the City of St. Louis under Title VII of the Civil Rights Act of 1964, the federal law that prohibits employment discrimination based on characteristics including sex. But there was a problem. The lower court said that Muldrow had not shown that the transfer caused her a significant employment disadvantage. After all, she still had the same rank and the same pay. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. So the case eventually reached the U.S. Supreme Court. The question was, how much harm does an employee have to suffer before a discriminatory job transfer violates Title VII? In 2024, the Supreme Court ruled for Muldrow. The court said an employee does not have to prove that a discriminatory transfer caused a major, substantial, or significant injury. Instead, the employee only has to show some harm involving the terms or conditions of employment. That could include things such as changes in duties, scheduling, benefits, or other important parts of the job. But the court also made clear that simply being unhappy about a transfer is not automatically enough. There still has to be some actual disadvantage connected to the employment. So the lesson from Muldrow versus City of St. Louis is this: your employer does not necessarily have to cut your salary or fire you before workplace discrimination can become illegal. Even a transfer where your paycheck stays exactly the same can potentially violate federal law if it causes you some employment harm and was made because of a protected characteristic, such as sex. Muldrow versus City of St. Louis, 2024. Sometimes, the question isn't whether you lost your job, it's whether discrimination made the job you already had worse. Thank you for watching. If you enjoyed this story, watch this case next.